Hello, everyone. We will be starting the webinar in about 4 minutes. Thank you for your patience, and we'll get going in a few minutes. Thank you, everyone, for tuning into today's session. We will start the webinar in about 2 minutes' time. Thank you. Prashanti, it is 11:59. We can start the webinar in about a minute's time. All right, it's 12 p.m. Eastern. We can get going. This is Vishal Sharma. I'm your moderator for today's session. I'm joined alongside Prashanti Reddy. Prashanti is an award winning immigration attorney specializing in immigration law with over 25 years of experience. She has been an esteemed member of the American Immigration Lawyers Association and the New York Bar Association and is currently admitted to the bar in New York. Prashanti is also a current advisor slash immigration counsel for Indian Consulate in New York and is actively involved in pro bono legal work as well. She has a list of achievements and recognitions in her name. Some of them are listed here, including listed by Forbes as one of New York City's best immigration lawyers in 2024. Without further ado, Prashanti, I would like you to take the floor, and maybe we can start with the immigration updates. And before we get started, for those who are joining us through multiple different platforms, because the stream is currently live on YouTube, LinkedIn, Facebook, and of course, directly through the streaming platform as well. At any time through the presentation, if you have questions, please drop in your question using the platform that you're streaming. Prashanti will have a Q&A session after her presentation, so we will be picking up your questions then. Thank you.
Thanks, Vishal, for that introduction. Hello, everyone, and welcome to another episode of our immigration webinar. Let's start with the immigration updates. If we can go to the first slide. I thought it would be best to discuss the visa bulletin first because that's something that has just happened. So February visa bulletin is the way, if I mean, it's the way you look at it. It could be either good news or bad news, but I look at it as good news because there's no retrogression. So you look at the positive side. There's been no movement either, not much forward movement, except for EB3 worldwide and for Mexico. We haven't seen much forward movement, but again, the good news is there's no retrogression. And the good news is that USCIS continues to use the dates for filing table and hasn't gone back to using the final action date table. So that's an important.
Prashanti, sorry to interrupt there. Uh, we've just gotten a feedback, unable to hear your voice. Can someone else comment? Just want to make sure that or the audience is able to hear Prashanti. I have
Hello.
no issues
Okay.
hearing Prashanti. I just want to make sure that everyone else does.
Can everyone hear
And
me?
for okay, yeah. I think Mani Raj, then it's an issue on your end. So maybe if you want, you can rejoin. Sorry about that, Prashanti. Please, let's continue.
No
And thank
problem.
you everyone for responding.
Thank you. It's good to confirm if everyone can hear me or not. So as I was saying, the visa bulletin, they're using the dates for filing, which is significant because usually by March or so they stop using the dates for filing and they use only the final action date because they come to the conclusion usually that they have enough numbers to advance for advance filing. So as you know, the dates for filing table is usually advance filing. Your priority date is not actually available, but they're allowing you to file a year or so in advance, or a few months in advance, depending on what they think the dates will be. The final action dates will be by the end of the year. So they look into the processing time and they see that 485 might take a year to process, and they're trying to guesstimate the processing time and what the numbers will be by the time the case gets processed. So that's what they're doing in the dates for filing, and so usually they stop using that completely, the dates for filing table, in March or April. So luckily we're still using it in February, but for all those who, especially those EB1 India cases who are qualified based on the dates for filing table and not based on final action date table, you absolutely have to file your 485 in February. Of course, by the first week or second week of February, you will know what March holds in store. But I wouldn't wait until then because, if you go to an attorney or try to file, second week of February, you may not have enough time to file it in 2 weeks. And also it's important to get all your documents together, birth certificates, non-availability, etc., etc. So there might be some documents that will take some time for you to produce. Next slide. So let's look at the February visa bulletin, the numbers exactly how they moved. If you look at this table, uh, if you look at um, F1, we're starting with the family-based categories. For Mexico, it's advanced by 3 months. And if you look at all other countries, there's been no advancement, only Mexico has advanced. For F2A, this is spouses and children of permanent residents. Again, you don't see any advancement in any country. So, just to tell you that F2A has moved significantly and it's now across the board February 2024. for the final action date table. So that's significant advancement. And, I'm hoping that there will be further advancement later on in the year as well. F2B, Mexico again advanced by 3 months, and there hasn't been advancement in any of the other countries. F3, again, no movement at all for any of the countries. F4, which is brothers and sisters of US citizens, no movement again, as you see. Next slide. This is the dates for filing table, and I was just telling you about the difference with the final action date table. The final action date table is what your priority date, where it actually is, and the dates for filing is where they expect it to be by the time your case gets processed. So if you look at this, usually the dates for filing table will be better than the final action date table. And the advantage of the DFF table is that you get to file your 485, you get to be on pending 485 status, you get advance parole, you get EAD, much better than being on a H1 status, trust me. So it's good to file if you qualify under this table. Again, here, Mexico advanced by 3 months. And for F1, for F2A, all regions advanced exactly by 1 month. If you look at it uniformly, all countries have advanced by 1 month. F2B, Mexico advanced by 3 months and no other change anywhere else. F3, no change. F4, no change. Next slide. For the final action dates for employment based, if you look at the movement from January to February, all this is, we're comparing last month to this month. EB1, no movement at all. EB1 has moved significantly in October, so we were not expecting any further forward movement. As long as there's no retrogression, I think it's good news. EB2, again, no movement. EB2 has always been backlogged, was backlogged throughout. Last year, we didn't see much forward movement for EB2, and no forward movement this month either. EB3, we have seen significant forward movement for EB3. But if you look at comparison last month to this month, not much forward movement except for worldwide. Mexico and Philippines advanced by 5 months, which is great. India, China are pretty backlogged as it is, so there's no forward movement. And this is the final action date table. Other workers, this is EB3 other workers, no movement. EB4 is religious work. EB4, no forward movement again. Certain religious workers, EB4, this category is unavailable and it will continue to be unavailable until the Congress says it isn't. EB5 is investment visas. And if you look at the unreserved category, there's no movement. And the EB5 for rural areas, which always has a different priority date and a better priority date than EB5 unreserved, is current right now. So that's great news as well, especially for China and India. Next slide. Let's go into the dates for filing table for employment-based categories. Again, EB1, no movement. EB2, no movement. EB3, Mexico and Philippines, moved by 3 months. EB3, other workers, no movement. EB4, no movement. And EB5 continues to be current for unreserved for all countries. And EB5 set aside continues to be current for all countries. So no movement though from January to now. Next slide. So in summary, we can see that Mexico and Philippines and all other countries have moved forward a bit, especially for EB3. India, China has remained static, and they're looking at, as I said, continuing to look at the dates for filing table. What is the predictions for March? For family base, we can expect no movement, that is no forward or backward movement, which is good news. Possibly for Mexico and China, we might see some measured forward movement. For employment based, EB3 will continue to see worldwide some small movement. EB1, EB2 China are likely to remain static. EB5 unreserved you might see some forward movement for India and China. EB5 set aside is anyway current for all countries. Next slide. Now let's look into another important immigration update. The Department of State has paused immigration visa processing for nationals of 75 countries. So this is important because this is an immigrant visa again, and might have some impact on the visa bulletin as well. That's why I put it right after the visa bulletin. So on January 14th last week, the US government announced that effective January 21st, which is this week, today, I believe, yesterday, the Department of State will pause issuance of all immigrant visas. So, all green card visas based on employment, based on family, will be paused and put into administrative processing. Um, Interviews will be scheduled, but there won't be any approvals. Everything will be put into administrative processing. They're doing this based on the public charge law, and there's a presumption of ineligibility or pause, and it's likely that as long as you belong to any of these countries, that is, if you are a national of any of the 75 countries, it applies only to immigrant visas, not to non-immigrant visas. And people who hold dual nationalities, they can use the passport from the other nationality, and if that nationality is not subject to this immigrant pause, then their case will continue to be processed. So, just to reiterate, it is a green card hold for all people who are outside the country, not people who are in the country. All the people who are applying for immigrant visas at the consulate. And if they belong to one of those 75 countries, then their immigrant visa will be put on hold. Everything will continue as per scheduled. Interviews will take place. But at the final stage, the approval will not be given. It'll be put on hold until further notification from the US government once they decide to lift the hold. Next. So, important exceptions, dual nationals, as I mentioned. There are some national interest exceptions, but these are expected to be granted only in limited circumstances. So, if you can show that getting a green card will be within the national interest of the US, so that is, if you are an EB1 category or EB2 NIW, you could possibly ask for an exception. Already visas issued, if they were issued as of yesterday, then they will not be revoked. If visa is printed but not yet delivered, then unfortunately it's going to be cancelled. So even if your case was approved after interview, you will not actually get the visa, so you will not be able to travel. And of significant importance is that there's no timeline being given for how long this pause will remain in effect, maybe for the entire duration of the Trump administration. Strategic considerations for people who are affected by this. You may need to decide on a case by case basis whether you want to proceed to the interview and get a refusal, or you want to delay your interview and being placed into an indefinite administrative processing. Of course, you can't continue to delay your interview. You might be able to delay it 1 or 2 times, but after that, you might have to go in for the interview, otherwise, your case will get denied in any case, right? So maybe delaying the interview is a good idea at this point, because you will get a chance to get another interview, and usually interviews are not available that frequently, so maybe the other interview will be delayed by 6 months or a year. That's what the hope is. Next slide. So again, we were talking about the impact of these immigrant visa numbers to the visa bulletin movement. There may be an impact or there may not be, depending on how the officers look at it. Visa numbers for those affected countries, if they are not actually issued, even if the priority dates are current and interviews are completed, then more visa numbers might become available. But if the visa number is issued after the approval and reserved, then of course the visa number will not become available. So we don't know as yet what they're going to be doing. Maybe it's a mixed bag. And if that's the case, then it will result in under utilization of the visa numbers in certain categories, especially. family based and also some employment based. Like we saw during the time of COVID, there was an underutilization at the consulates because all the consulates were closed, and we saw that the visa numbers rapidly did move forward, and there were additional visa numbers allocated from the basic 140,000, I think is the numbers usually that's allocated. There were 290,000 visas allocated in that year. So possible consequences could be, you know, inconsistent forward movement depending on what how they do this, potential spillovers to India and China since they are most affected by visa retrogression. And since these cases remain pending rather than denied, they may continue to occupy some space in the system, adding to the general backlog of I-130s and visa cases without producing actual approvals. Next slide. So that's the impact of this law on the visa bulletin. Now let's look into the topic of the hour, the new H-1B rules for registrations transitioning to weight wage selection and cap. So basically what this means is that they've found a new system to prioritize H-1B visa numbers. As you know, there is a limit on the number of H-1B visa numbers that can be allotted. It is 65,000 plus 20,000. So it's 85,000 visa numbers that are allocated every year to H-1Bs, and every year the demand is much more than the supply. So in order to find an effective process to eliminate cases, they introduced a registration process and a lottery process. So the registrations, you would register ahead of time and then you would be selected based on a random lottery selection because there are not enough numbers. If you have 400,000 people are filing, there are only 80,000 numbers allowed or 85,000 visa numbers available. Then what do they do with the rest of the cases, and how do they decide who gets in and who doesn't? It used to be a first come first serve, but the first come first serve didn't work because everybody was filing on the first day. They were receiving all 300,000 or 400,000 applications in one day, and this was overloading the post office, overloading USCIS, etc., etc. So, in order to deal with this, they came up with an effective method, which is a registration process. You just register, you don't file your entire application, and then there's a lottery selected based on the registration. And then once you are selected in the lottery, then you file your H-1B petition. This saves time, money, effort, everything. But however, instead of now having a random selection process, they are having a new process. This will replace the traditional random lottery process, and this is trying to incentivize higher paid individuals. And they are what they're saying, what USCIS or the present US administration is saying, that this is a good way for them to remove, to keep specialized talent rather than sourcing cheap labor. But it's questionable as to whether they'll get specialized talent simply by increasing the wages. And a lot of specialized talent may qualify for level 2 and not level 3 and level 4 because they're not senior, but they're still brilliant in what they do. So those people will be cut out of the system, and it's questionable as to whether the present system is not working. USCIS prevailing wage system is already higher than regular wages that US citizens get. So I don't see their argument holding any weight that they are removing cheap labor. H-1B people are not cheap labor because they're paid more than the US citizens. Let's go to the next slide. Let's look at what is really changing. Most significant change from the new regulation is the introduction of the weighted entries based on DOL's 4 wage levels. We already have wage levels. There are 4 wage levels. So while this lottery system has not been eliminated. Please keep that in mind. But the chances of getting approved in the lottery increase significantly depending on which wage level you are. So they've kind of gamed the system. They've kept the lottery, but they've made it a selective lottery system. So it's not completely based on luck. So if you're wage level two, if you're wage level four, then you get four entries into the lottery, so you're four times as likely to get selected into the lottery compared to the wage level one, because you get only one entry. Wage level two gets two entries into the lottery, and wage level three gets three entries into the lottery. So if you're wage level four, you get four entries into the lottery, and plus you get a selection into the master's cap. If you're a master's degree holder. So as it is, people who have US master's degree have a higher chance of getting selected. But if you have wage level four plus a master's degree in the US, of course, your chances of getting selected get really high. The additional requirement then, because they have to change the registration system, it's not going to be just a basic registration form where you just put in your employer information, your passport number, employer address, your name, etc. But you have to put in more information. They will be changing the registration form, and you'll have to put in the job title. So the job title has to be decided beforehand. You'll have to put in the wage level. You'll have to put in the SOC code. That's based on the job title, and you also have to put in the area of intended employment, because uh, the wage level really depends also on the geographic location where you're going to be working. So USCIS also now, because of this additional requirement, has stronger authority to deny or revoke petitions if you try to manipulate the SOC code and try to make the wage less by putting, like, say, putting a person into a systems analyst position instead of a software developer position, because systems analysts prevailing wage is less, so they might try to game the system by putting a systems analyst level 3 rather than putting it as a software engineer level 3, because a software engineer level 2 might be equivalent to a systems analyst level 3 or level 4. So they might try to game the system by putting a level 3, level 4, and changing the job title to achieve better results in the lottery. So USCIS is going to look at those kind of manipulation of the system. And they might deny an approved H1 if the H1 is approved, not approved, but filed. They might set an RFE on that basis. So they're going to be looking at that kind of fraud. Next slide. So this is just a table of the changes. The new process has a weighted system. The old process was purely random. The probability of selection is higher in the old process if you have level 4. In the old process, in the new process, it's higher. In the old process, it doesn't matter which wage level, it's the same for everyone. Information required in the new process, you have to enter all this information. In the old process, it was just basic beneficiary and company information. The primary goal in the new process is to prioritize high skilled, basically not, I won't say high skilled, I would say prioritize high wage individuals, or force employers to pay a higher wage, and thereby decreasing the number of H1s that will be filed. So they're trying to discourage employers from filing H1s and encourage only people who give a higher wage, and that automatically will lead to less number of H1s being filed. So they're just trying to restrict immigration. That's the primary goal, really. In the old system, the purpose of the lottery was very simple: just efficiently manage a high volume and keep it fair for everyone. There'll be much more integrity checks here. In the old system, they were just trying to make sure that one person enters into the lottery and one person gets one lottery entry. That was the integrity check that was being done. In the new system, there'll be other integrity checks. Like I said, they'll make sure that the proper wage, the proper job title and SOC code is being used. Next. What's the impact of the new H-1B rule? As I said, the selection process shifts heavily towards experienced applicants and higher paid applicants. So all your entry level student type applicants, it's a big disadvantage for them. International graduates will see their chances diminish. They only have a few chances in the lottery because they have 3 years. If you're STEM, you'll have 3 years on your OPT and you can apply 3 times. If you're regular non-STEM, you only can apply once. Now, the three chances for STEM may not be enough because they may not be able to get into the lottery. We have to wait and see how all this plays out. Change in compensation strategy for employers. They'll be pressured now to, if there is a key employer, to give them much more than what a US citizen gets. They'll have to give them level 2, level 3 salary, even if they're not that level, even if it's a startup and the person is a student, but maybe is brilliant in what they do. They'll have to give them level 3 salaries to increase their chances, or level 4 salaries to increase their chances. The cost of compliance is really high because there'll be more audits, more RFEs, etc. So just making it difficult all around for H-1B employers. Let's see if there's a silver lining in all this. If because of the 100,000, the other rule that we have, the 100,000 rule for people who apply for hedge funds from outside the country, since a lot of people will not now apply, a lot of your Wipros and the Tata's, TCS, these companies that previously filed hundreds, basically thousands of applications, will no longer be filing, and they are the ones that took up most of the quota. So, or at least more than 50% of the quota. So, if they are not filing, maybe even if you give level 2 salary, you might get into, your registration might be approved because that hundreds of thousands of those thousands of applications, or hundreds and thousands of applications that were coming from outside the country, they are no longer will be filed. So let's see how it plays out. This is the first year that this is happening. Of course, providing that there's no litigation on this, and we'll talk about that later, and providing the law goes through as is. Next. Just to say, if the law doesn't go through as is, then the chances of a student getting it are much higher because now you don't have this wage system, and the 100,000 law is still in place, and as the litigation has not been successful. So that continues to be in place, and so people who are in the country might have a better chance of getting picked. But if this law comes through as well, then it's a double whammy. Their chances will get diluted. So now let's look at that pending litigation. There is no pending litigation as of now, or nothing major at least. But this new rule is expected to be challenged, and the plaintiffs are likely to be businesses, industries, universities, hospitals, non-profit organizations, employers that are heavily reliant on students, basically your IT consulting companies or healthcare consulting companies who hire a lot of fresh graduates. Anticipated challenges are likely to be administrative procedural under the APA, Administrative Procedures Act. And based on previous precedent, such challenges are usually accompanied by a temporary restraining order. So they'll ask USCIS to stop, the court to compel USCIS to stop the wage law. So this may not be applicable this year, or there'll be a preliminary injunction to pause the implementation. So they'll try their best to do that. And then if that is allowed, then this year you will not see the wage being implemented. If it's not allowed, then this year the wage may be implemented because the case might take some time to go through the court, and you might see that it's not implemented next year. So there are several outcomes that are possible. Next. The likelihood of success, based on previous litigation and how courts are looking at these kind of things, It's not a travel ban. Travel ban, we are seeing like the $10,000 is a travel ban. We've seen that they have been successful because the courts are very reluctant to strike them down. But this kind of litigation, where we talk about APA and we talk about the regulation changing the actual law without Congress passing the law, we've seen that courts are usually more willing to strike down these laws or delay or block them. Um, there is a risk that it may not be delayed, the rule may be modified, or enforcement may be suspended while litigation is pending. So that's possible. Let's see what happens. Next slide. Let's look at what defects, if any, are there in this law that can be that the companies then can poke holes into them and put them as a strong defense. The main thing is based on APA, the Administrative Procedures Act. Basically, under 214G, the H-1B selection by numerical limitation historically is interpreted as a random selection when filing exceeds the cap. So it has to be a random selection, or it has to be first come, first serve. Congress has not at any point of time authorized USCIS to prioritize registrations based on wage level or impose some other substantive selection criteria at the registration stage. This is something that is not authorized by Congress. They are changing the H-1B rules. By doing this, USCIS does not have the authority to change H-1B rules without Congress action. So that's an important um, point. It is ultra virus, the law based on this point itself, that it exceeds the law. Next. Uh, it's arbitrary and capricious, they can say. Uh, if Congress really wanted a wage-based system, then the Congress would have said so. The Congress does not say anywhere that the registration has to be done or lottery has to be done based on a wage system. And the agency USCIS, if they're making any new law, it has to be based on evidence. It has to be reasoned out. Relevant factors has to be considered. You can't ignore interests of the stakeholders. So the arguments raised could be that USCIS failed to show evidence that the wage-based selection is better. They have not been able to show that it reduces fraud. They're not able to show that it improves program integrity, and neither does it show that it advances congressional intent, because there's no proof that Congress intended that it be a wage-based system. Next slide. And also, the rule ignores the interests of the stakeholders, right? It does not consider startups, nonprofits, universities, small businesses. And also, it's important to note that wage levels change based on geography. So if someone is in California, they are at a distinct disadvantage versus somebody who's in Utah, in some rural area, because the way they can easily afford a level 4 wage in Utah, but they can't in California. So what are they going to do? Move all their employees to Utah? So that doesn't make any sense, because you're allowing stakeholders to game the system by not having laws that make sense and are equal to everyone, right? So on this basis, courts have previously struck down immigration rules. These include the DACA rules, public charge rule, H-1B wage level rules in 2020 when they tried to do it during the last Trump administration. So let's see what happens this time. Also, they have said, they will say in litigation that it's improper use of the registration system, like we discussed. The registration system was formulated to create an administrative convenience to help in, properly giving everybody a fair chance and being able to properly um, use all these thousands of applications that come in and prevent the thousands of applications from coming in, right? Because previously it was didn't make administrative sense to have people file in thousands of applications and then send them all back. So administratively, it made sense to have this kind of a lottery system. It saved money, saved time, saved effort. So it made sense. But converting this into something that isn't like a ranking system is completely beyond their statutory authority. Next step. So they can't use an agency, cannot use a procedure to create a new law, which is what they're doing. Also, for any new procedure to come into place, there has to be a notice and comment period. So while they did follow the notice period, DHS did not adequately respond to significant public comments. They did not respond to economic harm to certain sections. They did not. They did not respond to comments that this would impact rural and low wage areas, especially in the healthcare sector. And the final rule completely differs from the previous rule. So they should maybe have uh, create made another registration period. They should have again published the rule and gone through the notice and comment period, because this rule differs completely from the previously uh, published rule. Cost benefit analysis that they did was incomplete, understated, so they were not able to show what was the cost benefit for USCIS. This has proved fatal for other immigration rules in the past, so let's see how that plays out. So, what is the practical takeaway? Employers should and applicants should imagine both scenarios could happen this year, and they should be prepared for both scenarios. Next slide. And that's the end of our presentation. We can go into the Q&A session.
Great. Thank you, Prashanti. To all the listeners and streamers, now is the time. If you have your questions ready, please start typing in. We'll take it one at a time. Prashanti, we do have a few questions, so I'll get started with them. All right. This one is from Ram Shetty. How is wage level decided if I get 300K new software role and file H1 and currently in 200K? Will the wage level be decided based on 300K or my previous 200K?
It'll be based on your new wage level, what your company is offering you on your H-1B. So you'll have to have a revised offer letter. They will file an LCA based on the new H-1B. So it doesn't matter what you were paid previously. What you're going to be paid now, the offer on your H-1B, that is important. It will be based on that.
Great, thank you. Next question is from Jacob Betty. I am Betty working as an RN in PA state, and my question is after my 3 years of completion in H-1B being visa, uh, am I eligible to renew the visa next 3 years without going to Kerala, India, or wants to go to the way to attend interview with Madras consulate again? And should the employer pay $1 lakh for the H-1B visa? I came here last September 10, 2025.
So basically, Betty is asking if she files a H-1B extension, can she file it or not, number one? And number two, will she be subject to the 100,000 rule if she files it? No, you're not subject. Yes, you can file for a H-1B extension because you're allowed a total of 6 years on your H-1B, and this rule or any other rule has not affected that ability to file a H-1B extension while you're in the country. And if you're filing the H1 extension while you're in the country, then the 100,000 rule doesn't apply to you, even if you go outside to get a visa. I hope that answers your question.
Great. And for those who are sending in your questions, thank you so much, first and foremost. Also, I would request you to keep your question to one single message. That way, it is easier for us and Prashanti to answer. Next one is Abhinav Gunda. Is the only wage level required at the time of registration, or we need to specify the SOC code and job title?
As I was saying, at the time of registration, you have to specify most probably the SOC code and job title also, based on which then they will look and see whether it is, they're going to reconfirm whether it's level 3 wage or level 2 wage. And unless you put that information to them, they will not be able to confirm whether you're using level 3 wage or level 2 wage or level 4 wage. So, most probably in the new registration form, all this information will be required.
All right. I'll go to Ravali Jajula. The question is, how does it impact the current H-1B people who are trying to change jobs or going for visa stamping?
So, neither does the 100,000 rule nor does the new registration rule impact people who are presently on a H1. So, it doesn't impact you at all.
Great. Next one is from Krishna Sai Kavuri. Can I file an H-1B even uh, and my initial OPT still being processing?
Uh, the person is asking if they can file a H1 even if the initial OPT is still being processed. You have to show what is the status, what is your status. Uh, if you're in a grace period status, you can because you will submit the receipt. But they may send an RFE asking for the approval before they actually approve your H1B. And remember this, if you're on OPT, then you're a cap case and the start date will be October 1st. And if you are in pending OPT status, then you'll be in cap status once you file your H1. And so that status will remain until the H1 comes into effect. So you can, in short. You can, but they may then ask for your approval at some point in an RFE.
Great. Next question is from Alfaz Sheikh. I don't know if I'll be able to show both the questions at the same time. No, I will do just one at a time. Um, do we still have the $100,000 H-1B fee is applicable?
It is applicable for people who are outside the country and for people whose H1 is approved through consular processing. So, say you're a H1, you file your H1 extension, and for some reason they could not approve your H1 extension, but they approved your H1. They could not give you an I-94 extension because maybe you could not show you were in status or something like that. Then they will approve your H1 for consular processing. If that happens, then you have to go outside the country, and then the 100,000 rule applies to you. Or say you file for H-1B consular processing instead of extension while you're in the country by mistake or for some reason your employer wants to do so. Anytime you click consular processing in the form, the $100,000 fee is applicable to you. Otherwise, it isn't. Any extension, change of status, amendment, 100,000 fee is not applicable.
Noted. Next one is from Ankit Harit. If we file consular processing for an employee who is on OPT, so that we need to pay him H-1B wages after 2 years when he traveled out and gets stamped, do we need to pay 100,000 for him?
Yes, because you filed a H1 for consular processing, you will have to file when he goes and gets stamped, and by then, if the rule still exists, then you'll have to file him the 100,000. You'll have to pay the 100,000.
All right. Alpha Sheikh had another question. Last year H-1B are still under process. When do you think it will get approved?
It should have gotten approved by now. Um, I would suggest that you convert to premium processing. Maybe there is some issue which they're looking into, and it's really hard to get their attention, and ask them to speed up the case unless you convert to premium processing. So it is way beyond processing time. It's unusual, but sometimes it happens. So I would convert to premium processing. I think that's the best way. If you're not able to do that, then at least follow up with USCIS. Your employer has to follow up through the app, through Emma, the chatbot, or you can also call USCIS. Your employer has to, rather. The beneficiary is not allowed to. They won't speak to the beneficiary.
Okay. Next question is from Maniraj Batula. What is the wage level number of attempts for a student who was on STEM OPT and convert to H-1B now as per the new H-1B rules, brackets weighted?
What is the wage level number of attempts for a student who was on STEM OPT? What is the number of attempts is what I understood. I'm going to, maybe it's two different questions. They're asking wage level and number of attempts. So if it's, you're asking about wage level, then wage level has to be level 4 to get the maximum chance of getting approved in the registration, in the lottery. There is no number of attempts. As long as you're in status, you can continue to apply for the lottery.
All right. Next one is from Dhimant Reddy Shankul. I wanted to ask whether there is any active lawsuits currently pending in court that challenge USCIS's wage level system. If a lawsuit is already open, could it be taken up by a judge or otherwise move forward while USCIS is conducting and approving the H-1B lottery in March?
I'm not aware of any lawsuits, but I do believe that they are in the offing. But I don't think any significant lawsuits have actually been filed as yet because the law has just come into effect today. So we can expect to see something from the usual groups, hospitals, industry, chambers of commerce, etc., etc. And yes, a judge can stop the implementation of the wage rule, um, or halt it. But of course, after it's already happened, there's not much that they can do. So the lawsuits have to be filed before March, so that they can at least uh, stop the implementation of it temporarily, to put a temporary restraining order, which is called a TRO, so that it's not implemented until at least the judge makes the decision, because it'll take time for the entire process. So yeah, the ideal thing to happen is that somebody files a lawsuit, organizations file a lawsuit either this month or next month, and they file it along with a restraining order, the TRO, request for a TRO, and then the judge approves the TRO, and then in March, the USCIS is not able to implement the new wage system because of the TRO in place.
Okay. Moving to the next one from Ram Shetty. Um, if a SDE 3 wage level falls in level 4 in a location and has got approved FY27, if he/she changes job in 2028 and downgraded to SDE2, which falls in level 2, what happens here?
This is brilliant, Ram. Only, I mean, there's always loopholes, right? And this is one of them that you've just brought to our attention. Yeah, absolutely. I mean, this is what people are going to be trying to do. They will maybe file the case under level 4 and then file an amendment 6 months later. What's stopping them from doing that, right? Um, but of course, when you file the amendment to level 3 then or level 2, then USCIS is going to question whether it is a bona fide amendment or not, because what caused the lowering in the wage level? You have to show all that. You can't just blindly put level 4 and then put level 3 and put how you give proof that it is a genuine change and not something that was orchestrated only for the sake of getting the lottery system. This is what they're going to be what they're talking about. Not just are they going to be looking at what job title you used, they're also going to be looking at the geography, whether you moved some to some state simply to decrease the wages and be able to give wage level 4, uh, or if you did this, if you're filing an amendment because the previous wage level is too high and you just did that for registration purposes. So I guess they'll send an RFE if they see that they suspect some fraud involved there. But this is what everybody's going to be doing for sure.
All right. I'll go to the next one from Kashish PH. If I currently make a level 2 wage, but my employer is willing to bump my salary to level 3 wage, does this mean the wage increase needs to be applied before they file for my H-1B lottery or before the H-1B application?
No, neither. You just have to get paid that salary once your H1 gets approved. You don't need to do that before. So it'll only be after October 1st that you need to get that new salary once the H1B gets approved and after October 1st.
Okay. Next one is from Gautam Krishnan. Um, First of all, thank you for scheduling this webinar. Appreciate it. I have a question regarding the H-1B process. Suppose if I file an H-1B registration for a beneficiary with the application of placing this individual at a specific client location. After the H-1B registration is selected in the lottery process, I later learn that the client is no longer interested in hiring this candidate. In such a scenario, at the time of filing the H-1B petition, is it permissible to change the wage level? And there's an additional question. Additionally, in this situation, would it be possible to file the H-1B petition using in-house project details instead of a client project?
So the wage level does not depend on the client, correct? The wage level is what you give your employee internally based on how you calculate your wage levels in your company. Say you might have a methodology in your company where you give level 2 salary to people who have 2 years of experience, or level 3 salary to someone who has 6 years of experience, whatever your methodology is. So that is not based on what the client requirements are. Though you may think that because, I know there is this percentage sharing and this and that. But from the H1B regulation point of view, that is not how it works. So even if you change to a different client, your wage level will not change, should not change. Yes, if you change to a different client, your location might change. And if the location changes, then you still continue to pay wage level 3, but the wage level may be less because the person is in Utah and the person is working in house. So as long as you're able to uh, document all this as the truth and show the factual uh, aspect of it, then yes, you should be able to do it. Again, the USCIS is looking to see whether you're trying to game the system or there is a genuine need.
Noted. Moving on to the next question from Veena Singh. Will there be any impact on the wage level on H-1B transfer?
No, there shouldn't be because that the wage levels that way have not changed. It's just the registration. They're looking at wage levels, so there's no registration for H1 transfers required, so it doesn't change. The only time this will have an impact is if they publish a law where they're changing the wage levels itself. And they say that you have to use level 3 wage for all H1B employees. So then it will impact everyone. Right now, it's only impacting those people who need to file registrations. And that is the new H1Bs.
All right. I'll go to the last question that we've received from the stream today. We still have about 5 minutes. So if you have any questions, now is your chance to put in. Next question is from Chandana Priya Naidu. If someone's H-1B was approved through consular processing and they're currently outside the US, but they already have an approved I-140 and a valid H-1B approval, does transferring to a new employer still require the 100K fee?
So if someone's H-1B, let me read it again. If someone's H-1B was approved through consular processing and they're currently outside the US, uh, so the H-1B 100,000 fee applies only if you have filed H1 after the effective date of the new law. If you filed your H1 before the date that the new law was published, then it does not affect you even though you're outside the country. I hope that answers your question.
Yeah, great. Well, the last one is really not a question but a comment for you, Prashanti. So maybe you can read it privately there.
Yeah.
Uh, we still have 3 minutes. If any of you have any questions, I know I can see many of you are still with us. So we still have a few minutes. There you go. The next one is in. This is from Dhimant Reddy Shanku. If the job is fully remote, can we choose a work location in a rural or local wage area before the H-1B lottery so that the wage level qualifies for level 3 or level 4? If we do this, what possible consequences could we face later with USCIS or the Department of Labor, such as issues during the adjudication, audits, amendments, or extensions?
Yeah, absolutely. I mean, that's what I was saying, right? There's so many loopholes in this law, and part of a lawsuit will talk about these loopholes that, and I talked about them also, and Ram also talked about them, right? So this is definitely a loophole in the law that will be used. Just as the registration process, people started filing 10, 20, 50, 100 registrations, right? Because they didn't write the law properly, and they allowed that to happen. And it happened, and then they had to face the consequences of it, and then they had to change the law. So this law is also written in the same way, without thinking, without analyzing it properly. If somebody who's living in California has to pay more than somebody living in Nevada or somewhere else, or in some rural area, obviously it is unfair, right? It's an unfair system. So you're asking someone to live somewhere, and that's not the intended consequence. So when they wrote the law, they did not look at these consequences, which they should have, because they have lawyers, they have people, experts, that advise them. But I'm not sure why they don't do it. So yes, absolutely. If you move to a lower wage area, and there are plenty of areas, then you will pay a lesser rate. And most IT professionals work remotely anyway, so as long as they're willing to move to those areas and work in those areas, then yeah, you can make use of the lower wage, because that's what the wage is. But of course, you cannot say that they're living in Nevada, but they actually live in California. You can't do that. That would be fraud. But if they're actually living there, and what is stopping you from doing it? USCIS might come to its senses 3 years later, when this everyone starts doing that, and they might change the law. But yes, I mean, I don't see, as per the law as it's presently written, if the person wants to go live in some other place, they're free to, and then you're free to file an application.
All right, I'll go to the next one. Ankit Harit asks, if my employee is working from home as his project is remote, is it okay for him to move to a cheaper location and once his H-1B gets approved that he can work from a location in same county?
Yeah, we discussed this already. We are already talking about loopholes even before the law comes into effect. I don't know why USCIS doesn't see these loopholes. But yeah, I mean, your wage depends on, if you're working remotely, it depends on where you're living. Of course, please keep in mind, if everybody starts doing this, of course, you're improving the economy of those rural areas, which is great, an unintended effect, but good for those rural areas. Um, but USCIS might, start enforcing and pushing back on this, and might change the law, which it should. do we even now? But as of now, yes, the wage level depends on your area of intended employment.
Great. I know we are slightly over time, but I'll still take the last couple of questions that we have. Next one is from Ravi Kiran. Uh, if we are hiring a beneficiary who already have a I-797 approval notice valid till 2027 and visa stamped on his passport, but he never traveled to the US yet. During this scenario, if employee applied for TCS or Wipro and Wipro file transfer within India, kindly clarify following questions. Does 100K is applied for this type of beneficiary? If doesn't apply, then can he travel to US once Wipro petition has been approved and travel on TCS visa stamp is permissible?
Yes, he can travel on the TCS visa stamp. The visa stamp does not have to be from the person who initially approved the H-1B. You can use a TCS stamp and then Wipro I-129 or I-797 and travel that way. But unfortunately, when Wipro is filing, it's not considered to be a transfer. That's a key thing that you have to remember. If the person is outside the country, you cannot file a transfer. It is consular processing. You have to check box consular processing. If you're checking box consular processing, then of course the 100,000 rule applies. So it's consular processing. It's not a transfer because the person is not in the country. The person, of course, could travel back to the US and then file a transfer, in which case, or travel on a H4 or not on a B2, but travel on some other status and file a change of status, then of course the 100,000 doesn't apply. But while he's outside the country, the only kind of H1 that can be filed is consular processing, and for all consular processing cases, 100K applies.
Okay. Next one is from Sudha Neelam. EB to India predictions for March 2026.
I don't expect EB2 to move forward. It hasn't moved forward at all last year. Very slow progress. It has moved, but very slow progress. So I don't see significant progress in March. That's my prediction. It's either stays the same. I don't expect retrogression also. Either stays the same or maybe moves by a week or so. I hope I'm wrong. I hope it moves forward, but that's what I'm thinking.
Okay, well, on that note, we can wrap up today's session. Thank you everyone for joining in. Prashanti, this definitely tells me that we should have our next session soon. There are lots and lots of questions and queries. And before I forget, for all of you joining in, we are happy to give away a token of appreciation. That would be a one-on-one consulting session with Prashanti. So if you are interested in applying for that early bird complimentary session, all you have to do is drop in your email and someone from our team will reach out to you. You can drop in your email using this stream, or you can reach out to us in any of our social platforms. Prashanti, any final words before we depart for today's session?
I just like to thank everyone for joining in, and I look forward to another equally interesting session on the topic of the hour, whatever that might be. Maybe it'll be H1s. And I'll see you again next month. Thank you for joining, and please join again next month.
Thank you. Have a good one. Bye. As we close today's session, I would also like to remind everyone Prashanti is now releasing videos on a weekly basis. There are a couple of video series that goes out every week. So please subscribe to our YouTube channel. That's where we are holding all the repository of videos. Other than that, please do follow us on socials, including LinkedIn and Facebook and our Instagram if you're there. There is meaningful content coming your way. On that note, I will be ending today's stream. Thank you.